Jamie Lee Ross.
I move that the question be now put.
I'll hear from Keith Locke.
Thank you, Mr. Chair. I think it's worthwhile sort of teasing out particularly the Labor argument in this debate, and that is that a mistake was made and that the intention of Parliament was not reflected in the final bill. Well, I would come at it from the point of view of a judge. When judges look at legislation, they look for a start at what the law actually says. And it's quite clear in any reading of the law what it actually says, that there is an exclusion from taking identifying particulars from young people with low-level offending who haven't been convicted as such, but have suffered very low penalties for their disobeying of the law. They've got under this 283, Clause 280, Section 283 in the Children's and Young Persons and Families Act 1989. There's Group 1 responses up to Group 7 responses, and Group 1 responses are when the youth court discharges the person from proceedings without further order or penalty, and the second part of that is admonish the young person. Well, the judge looking at that would think, well, perhaps, as my colleague has said, there's a distinction here between young people and old people. That's very much the modern thing, so I'll read the law as it is written. But the other thing judges do is they look at the debate in Parliament and look at particularly the third reading speeches, but even the whole debate. And when you look at the whole debate in the 2008 debate around the Policing Act, the conclusion, and we've got some people in the very rush time we've had to have a look through all of this stuff, and they've not, quote, located anything which indicates a specific policy position was taken on this issue. That is, the parties in this House, including the government, including the Labor government, the Labor-led government that was moving the bill, didn't put forward in any of the parliamentary debates any specific policy position, nor did any other party, including the Greens. And I was the police spokesperson for the Greens during that time and for this bill, and there was no conception that there was any misinterpretation of that particular provision or any policy position that would lead a judge, to offer any other interpretation other than what the legislation actually means. And if you look back at, and then people say, oh, well, you've got to go back to the 1958 Act and what that meant. That was written in 1958 for an entirely different time where, as my colleague says, there wasn't any differentiation between older and younger offenders. There was no Children and Young Persons Act, no Youth Court, etc., etc. If the government had put out in 2008 an options paper saying, well, one option is that we distinguish between young people and older people and people who have been convicted and people who haven't, and referred back to the Children and Young Persons Act and all the rest of it, and said to the parties in the House, which option are we going to go down? The government suggests this option. We had a debate around it. Then there would be some clarity and it would be quite clear what was meant by Parliament. But Parliament, I think the fundamental misconception is that both Labor and National are defining Parliament as the government, and that's very offensive to other parties in an MMP climate. We've never been part of the government. We come to this debate and all the debates in this House in good faith, discussing the bills as they are, the wording as they are, the motivations as they're put out. There was no motivation or wording or anything whatsoever to construct the interpretation that Labor is now putting on this bill, and no explanation of how it fitted in with previous legislation, including the 1958 legislation on this issue, and to what extent that took account of the huge changes in the way we respond to youth offending now as compared with back in 1958. And Carol Beaumont said, oh, well, there was a drafting error and some words were missed out. Well, if that is the case, let us see the proof. Let us see the words that were missed out. I don't think that is the situation, but I challenge anyone in Labour to say that.
The question is that Part 1 stand part. Those of that opinion will say aye. For the contrary, no. The ayes have it. Is that party votes called for? I'll ask the clerk for a party vote.
New Zealand National.
57 votes in favour.
New Zealand Labour.
42 votes in favour.
Green Party.
9 opposed.
ACT New Zealand.
5 in favour.
Māori Party.
3 opposed.
Progressive.
1 in favour.
United Future.
1 vote in favour.
Mana. Honourable Chris Carter.
1 opposed.
Any other votes?
Members, the ayes are 116. The
106.
My apologies. More members than we've got. The ayes are 96. The noes are 13. Part 1 will stand part. We now move to debate on Clause 6, and the question is, a Part 2 stand part. The Honourable Judith Collins.
Thank you, Mr Chairman. Mr Chairman,